Partner with Culver Law in the Disputed Wills Trust and Probate team. I'm also a council member for Bristol Law Society, so I'm very pleased to be able to host the 5th in a series of private client webinars for 2024, and this time it's on the intricacies of executor removal. A few bits of housekeeping for today before I introduce our speaker. So John will be speaking for roughly about 45 to 50 minutes with some time for questions at the end. If there are any questions, please submit these in the Q&A box and I'll work through these and raise them with him at the end. The webinar is being recorded and we will share the recording and a copy of the slides once the session has been finished and likely with you by the end of the week. Looking forward for 2025, if there are any topics that you'd like us to consider or tackle, please do let us know, and any other feedback or anything else, please let us know to Bristol Law Society. You'll also receive very shortly details of some of the events we have already planned for 2025, which are coming up in the early part of the year. So in the meantime, and for today, I'm pleased to introduce our speaker, John Davies, who is a senior associate and a solicitor advocate at Hugh James in their private wealth and disputes team. He'll be speaking on the topic of the intricacies of executor removal. So I'll hand over to him now.
Hello, everyone. Thank you for coming. I'm looking at the time. I think everyone should be in by now who should be here. So I'll just crack on. So as has been said, it's the intricacies of removal of executors, or removal of executors because it's easier to say. So this is the topics that we'll be going through today. Start with pre-grant, what you can do to remove executors, moving through to post-grant, the Section 50 applications, and then just looking at other issues that sometimes maybe cause a bit of concern or simply trip people up. So hopefully this will help people in the future. So the first slide here then is renunciation and intermeddling. So obviously renouncing a position as executor is the easiest way to deal with the removal of an executor. It's incredibly straightforward. Most of you I know are going to be sitting there now thinking, well, I knew that. Honestly, there is more to it than that. So there's two particular drawbacks to it. First of all is that you need the executor's agreement to their removal. Obviously, not everyone is happy to do that. The second one, and it's a bit more detailed, is what happens if someone is intermeddled in an estate. Because once you've intermeddled, you actually then lose that ability to renounce. So first question, what is intermeddling? This is the boring part. I'm sorry, everyone. There's a definition. I won't read it out because it's on the screen for you anyway, but essentially what happens is if someone acts on the basis that they're the personal representative, then they can be held out to be that personal representative and equally liable. So if they've acted in a way that they are actually administering an estate when they're not the executor, either at all or yet, then they become an executor decent tort. Ultimately, this can prevent them from renouncing later on, which can cause difficulties for people when it actually comes to administering the estate properly. One of the questions that frequently gets asked is what happens if someone has intermeddled, but yet they still try to renounce, as purported renouncing. Ultimately, they can still be found liable even after they've purportedly renounced if they don't do it with an order of the court. So that's where these applications will really come in handy if you ever find yourself in that situation. So intermeddling practically is a nightmare to define. There's no one set guidance for it. It's a very varied definition depending on which source you go to. The general rule is that if you've dealt with the assets of the estate, so selling, disposing of them, transferring them, carrying on business, basically reading through that top list, those are the ones that will 99% of the time be considered intermeddling. There's other actions that a lot of people take in good faith. It happens quite frequently. You'll see people arrange funerals and simply collect assets and try and protect them. And it's a wonderful thing for people to want to do from a moral perspective. It's just that problem if they take it a bit too far and start dealing with things, then ultimately they can become that executive decent tort. So generally speaking, arranging funerals, effecting repairs to property and securing property in particular is one that doesn't usually attract an intermeddled status. Those are things that you can quite comfortably do. The difficulty, obviously, as I say, is when you have intermeddled, you can't then renounce, and that's when other things are needed. So it leads me into my next slide here. If someone has intermeddled, even if they weren't named as an executor, even if they didn't really intend to intermeddle, the problem is at that point they can't voluntarily renounce even if they want to. So that's when the Section 116 application is needed, or a Section 50 applications. That's Section 116 of the Senior Courts Act 1981 and Section 50 of the Administration of Justice Act 1985. So if you need those, we'll start with Section 116. So Section 116 is particularly for pre-grant applications only. It does not apply post-grant. So if someone has obtained grant of probate, you can't use Section 116 anymore. Um, it's found in the wording, it's who would have been entitled to take grant can be replaced. And the courts have ruled time and time again that if someone tries to bring a post-grant Section 116 application, then ultimately they're just going to bounce it out because they say they don't have jurisdiction to deal with it on that basis. So the way a Section 116 application works, it's not technically removal directly. What it does is it moves someone who's lower in the priority and moves them up the rankings, basically. So it makes them the person that has the highest authority to take grant. That's obviously very useful for a number of reasons that I'll come to, but it has the same effect as the person who would be taking grant is essentially passed over, they're superseded, and it allows you to have someone else take the grant in their place. Section 116 is used quite frequently because you'll note the tests in the Act are any special circumstances, necessary or expedient. It's so varied, it's so broad that the court just has the power to simply rule on what they think is best for the estate. And a lot of people will use it for many different reasons, simply because that test is so broad. So the Section 116 application, as I say, you've got your obvious ones like if someone's unwilling to take grant, you can pass them over. Someone who's old and infirm, you can pass them over as well. Some of the more interesting ones, so as I've touched on already, that intermeddling person, that executor decentor, they might have in good faith gone and said, well, I know the deceased wanted me to transfer this property to someone, so they've gone ahead and given items away, they've sold stuff, and all in good faith, and then have found out they're not the executor. Common sense says that they need to renounce at that point, but obviously they can't because they've lost that ability. So a Section 116 application for someone who is um, entitled to take grant by their own right can simply pass over the executor decentor and end what they've been doing. Another one that it's useful for is grants in favours of creditors. So a bit of caution if you're using this application for that reason. The courts do like to see it being made by a large creditor to the estate. They won't simply have someone that's owed a little bit of money. They do want to see that big involvement. Maybe it's a mortgagee or something like that with a crystallized charge over the estate. Another useful one is when there's missing beneficiaries. Ultimately, if they can't be found, they can't take grant. This just means that someone else can take control, and it's just useful. One that's interesting, I've seen used only once or twice, but I think it should be used more, is actually kind of an intersection with murder investigations and forfeiture. So if someone has been accused of murdering the deceased, but they're the named executor, obviously they're not going to be the most appropriate person to be dealing with the administration of that estate, especially if forfeiture might apply to whatever inheritance they're going to be getting. So ultimately, you can use the Section 116 application and say that is a special circumstance. Court, I think that we should have someone else in favour of this, and that I would be very surprised if the court didn't agree with the application on that basis. One that you see quite frequently as well, and it's a little bit extra, it's maybe not for removal of executors, but it's where there's a burial dispute. Section 116 applications are used incredibly frequently because although the court has inherent jurisdiction to make rulings on things like burial disputes and who has control of funerals, etc. The problem is that it's relying on really archaic rules. They're not always necessarily known. It's all very inherent, so there's no real test for what they need. A Section 116 application is just the easiest way to deal with it because there is that statutory framework. And actually what the court can do is, by passing over someone who maybe is party to that burial dispute, they can actually say, well, someone else is entitled to grant, and therefore they're now the person entitled to deal with the burial because that responsibility falls naturally to a personal representative anyway. So that's just another useful aside for Section 116 applications, is that you can just resolve most disputes, especially where people are equally entitled to grant, by using this procedure to pass over and simply move on to the next person. So with a Section 116 application, there's two different ways to do it. The usual way that you'll see it being made is in accordance with the non-contentious probate rules to the Probate Registry. You can do that in accordance with Rule 52, that needs the affidavit or witness statement to be sent to the Probate Registry. So I've put a note in the slide that says the Probate Registry will be able to deal with the application on summary without notice. Yes, they can. In theory, they can do so. But with a Section 116 application, unless every single person who's affected by it has consented, or there is an insanely good reason why it should be made, then ultimately the Probate Registry will usually ask for further evidence, or will go on to make directions to say, well, we need it served on all the parties so that people can actually make representations. The point is that unless there's a clear-cut reason, or as I say, everyone agrees, the courts are just going to want to be able to say, well, everyone had their say, and I've made that ruling based on absolutely everything I've heard. So when you're making it in the probate registry, if they do go ahead and they actually list directions, usually everything will be done on summons. So if any of you have dealt with summons before, it's very strange. It's still archaic, but essentially you'll get listed a hearing date quite soon into the future. Usually the court will do it on the basis that the opposing parties, once they're served, provide opposing witness statements. Then the court will make a decision as to whether that hearing is to be done on paper, with the other witness statements being considered as well, or whether it's actually to be attended in the probate registry. The second way is with an application to the High Court. It's essentially the same application, just done on your usual type of claim forms. The benefit to it is that where the probate registry 99 times out of 100 will make a direction that people attend, that people file witness statements and things like that, then ultimately that kind of short circuits all of that weight, because the High Court will simply say, you have a chance to respond, and they'll get the information straight off the bat. The problem, I suppose, with it is that that small chance that you could have it dealt with on summons on paper, without summons on papers, is lost if you do it in the High Court, because the High Court will say, we need witness statements from the other parties and we will have a hearing about this. So if there's no urgency to it, I'd recommend that you make the application in the probate registry. See if the probate registry will give you that opportunity to have it dealt with on papers, because it is quicker, more simple, and it just makes everyone happy, basically. If there's a sense of urgency to it, this needs to be done now, then I'd be saying look at the High Court instead, potentially. So there's another one here that I've put in. So it's a citation, the next ones I'm looking at. So a lot of people might disagree that this actually belongs in this webinar. So a citation technically doesn't remove an executor at all. It makes an executor lose the right to apply to be the executor. So there's three types of citation. The one we'd be looking at is to accept or refuse a grant. I'm going to put in a caution here, because it is that high risk, high reward tactic if you need to remove an executor in a dispute. There's a lot of downside to it if the executor chooses to engage. This is the one to use if the executor has simply refused to engage, doesn't want to take grant, but also doesn't want to renounce. They are simply holding up the matter. So citation, use with caution when you come to it. So as I say, it's that accept or refuse a grant that we're looking at. So the citation, essentially what it does, it's another type of specific summons, but it's called the citation in the probate registry, where when you send it to the executor who's not responding, who's not dealing with the matter, they then have 8 days to enter an appearance in the probate registry. Otherwise, their ability to take grant is cleared off. So you have essentially the 8 days to do that. And if they do actually enter the appearance, I'll come to the difficulties, but if they don't, then ultimately it resolves what could be a very long and contentious dispute if it was dealt with any other way. Ultimately, with the citation, you prepare it, you send it to the probate registry. Is a minimal fee compared to any type of litigation. It's a £4 fee. You file it with a draft witness statement, and once the court are happy with it, they'll seal it all. You serve it, and from there, the 8 days start. And once the 8 days are done, it's simply they're cleared off. You can make an application for a grant of probate on the next entitled person if needs be. I've put a brief note in there about substituted service because one of the key concerns with the citation is if someone is actively trying to avoid dealing with an estate, then ultimately they're probably going to try and duck service as well. With this, you can ask for substituted service. So the court will usually do that instead by advertisement. They don't particularly want you to post it because there's always the question of has post been received. They don't deal with it that way. Usually they will ask you to draft up an advertisement. They'll check it again, a £4 fee. So minimal in terms of what you could expect for litigation. You can advertise it, and then within the 8 days, again, if there's no response, it's cleared off. So, just my note there as well. So, one of the things I've seen before is with a citation, sometimes the executor will make the appearance and then simply go back to bed, not deal with the matter at all, and again continue to frustrate things. If they do that, you can make an application on summons, and the court will simply look at it as if they haven't made the appearance because they've taken no action once that's been done. So even if there is someone that you think is smart enough to frustrate you by making the appearance but still reluctant enough not to proceed from there, the citation can still work. But it brings me then on to the downside. So if the appearance is entered and you do have an executor that thinks, well, actually, I am willing to take it if I'm going to be shuffled off the order of priority, then ultimately they can obtain the grant without notice by lodging a witness statement or affidavit in the registry where the citation was issued. So that happens even if there's a caveat on the estate because it's deemed that the person that's obviously cited them, they are challenging them to take grant. So even if you have the caveat and then you issue the citation, they can essentially sidestep the caveat altogether. So only use the caveat where you are certain they're not going to engage. And I say that in that tone because I cannot stress it enough. If you have a really cunning executor that wants to frustrate you and wants to do it in a way, um, in a board type of way, they can jump on that and use that as an opportunity to actually obtain grant. If you do end up in that situation where you honestly believe the executive won't want to take grant, but then ultimately they do take up the appearance and obtain grant, you need to do the Section 50 applications because the Section 116 application only applies pre-grant. So you lose that ability and you have to go straight for Section 50 applications. And that brings me nicely on to Section 50 applications. So this is the one that is the most commonly used. It is the one that everyone will go to because it applies pre and post grant. There's very broad discretion again for the court to look at things. It's quite simply the easiest way to deal with it, but it can be more expensive, which is why if you can do the citation or if you can do a Section 116 application and it's a small estate, it's usually worthwhile investigating those first. If you've got a complex estate which has a high level of liquidity and a dispute's arisen, Section 50 will tend to be the one that's the most appropriate because it is just much more simplistic. So it's Section 50 subsection 1. Essentially, what the court can do is they can remove and replace any executors that they want, provided that they don't remove all of the executors. There must always be the replacement of at least one executor. It can be used for, as I say, pre and post grant, and that's confirmed by the Goodman case there. It's therefore quite all-encompassing, especially if you don't know whether a grant application has been made. So if someone has applied but you didn't know it, you could ultimately fall foul if you've made a Section 116 application when it had been made, but then you have the grant that's been issued in the meantime whilst the court are dealing with it. So the benefit as well with this Section 50 application is there's a set procedure for appointing independent administrators, which is just a lot more straightforward than having to deal with on a Section 116. Section 116, you have to prove why that independent person would be a special circumstance, why they're necessary and expedient. With Section 50, there's a particular way that the court will deal with it, which I'll come to, which is a lot more straightforward. The other point to note is that although a Section 50 application is most of the time a contested application, if you have a situation where you have, say, that intermeddling person or just an executor that's taken grant in good faith, they're looking now to step down because something else has arisen that means they can't now continue, you can make a Section 50 application by consent. Again, it makes it cheaper, more cost effective and quicker than if you deal with a Section 116. So that's only by consent. So you basically, your order is Section 50 is the most expensive if it's contested, then a Section 116, then the consented Section 50 is the cheapest and most effective way of dealing with it, unless you have that option to take the citation. And that's probably the order that I would look at dealing with removal if you have the opportunity. So with the Section 50 application, bit of a debate in the civil procedure rules because a lot of the probate applications are required to be made on a Part 8 application. And that's, I think it's a form N208, but don't quote me, I forgot to write it in my notes. Ultimately, it's the Part 7 or Part 8 can be used because this one doesn't technically specify it has to be Part 8. So Part 8 is commonly favoured, but the court will say if there's a substantial dispute of fact, what that is quite largely undefined, then they're going to prefer Part 7. So the very common thing that will happen is that you, sorry, excuse me, the Part 8 procedure is used to begin with, and then it's transferred over to the Part 7 procedure by the court if they deem there is that substantial dispute of fact in there. So CPR 57.13 needs to be a High Court case, County Court can't deal with it, and every personal representative needs to be added to the application. So that is the existing personal representatives. Say, for example, the proposed person, they can be a party to it, yes. But if you have, for example, an independent person that you're looking to apply, then ultimately they don't need to be a party. There's, as I say, the set way to deal with that. So the way to deal with it, with the claim form, you have to have a signed consent to act and evidence of the fitness of the proposed substitute. So the consent to act is literally just a one-page form. I, whoever, consent to act as the executor, and signature, done. When you have the evidence to fitness of the proposed substitute, because most independent people are professionals, what we usually do is we'll get a witness statement from a colleague of theirs that can say they've worked X number of years doing probate work, they have this experience of being an administrator, they know what they're doing, and they're held in good esteem, basically. And that's usually all that's required there. They're not usually quite detailed. They're usually two-page witness statements. The court simply want to know that they are appointing someone who actually knows what they're doing rather than adding more fuel to what is potentially a fire already. So moving on to then consented applications, the two ways to do it, either when you do the acknowledgements of service, you'll send them out with a letter to all the parties that have already consented saying, if you're happy, tick the box saying, we do not object. And once the court, provided everyone returns that form that says they do not object, then ultimately the court can just go ahead to make the order. one that I tend to find maybe makes the procedure a little quicker is once you've served the application, do a consent order that simply gives the order that you want. So it'll be whoever is removed, the new person is appointed, the old outgoing executor provides all of the documents and money and estate assets they have to the person coming in. An inventory and account be provided as a usual provision, and whatever costs order that you want in there, simply make that a consent order to have everyone sign and file that with the court. It does incur a fee when you file the consent order, but ultimately what I've tended to find is that when all the acknowledgements of service are with the court, because there's not an automatic process in the court that says, well, everyone's returned saying okay, sometimes they'll receive the acknowledgements of service and almost ignore the fact that actually everyone's consented, and you have to remind them. The consent order just brings it to the forefront and says, well, actually, no, everyone has consented, deal with this, please. And the court are quite willing to deal with it on the consent order. For the contested applications, as I say, so the note there, as the Part 8 procedure is usually used, the court can transfer it over to Part 7, but that usually comes later. So where you do the Part 8 procedure, witness evidence will be filed if people do intend to object. Usual objections are, I don't agree that either the person coming in has the relevant experience. So that's usually if it's a lay executor being proposed, or lay administrator, I should say. Or if it's a professional administrator, usually the objection you get is, well, actually, this is going to take a considerable chunk of the estate in legal fees, so we don't want the independent, and they will usually propose someone else, usually themselves, to fill in the role. So when is it needed? Pretty much this can be used whenever you want. This is pre-post grant. They can be done if there's disputes between executors, they can't agree with which way to deal with the estate, people aren't dealing with their duties properly, if people are simply hiding things. So one of the common ones that I've seen before is someone that's refused to provide account information to any of the beneficiaries. We've threatened the inventory and account, they've not dealt with things, and then ultimately we've said, well, now they're breaching their duties, so we'll get the Section 50 application. And the other one is if there's a conflict between the executor's role and their own interests. So the common one we'll see for this is where someone decides they're going to make a claim against the estate on which they act as administrator. The point is that they would then be the person entitled to both investigate their claim and bring the claim as well. So it's a clear conflict, and we usually suggest that people get removed and replaced by someone independent at that point. And that typically is where we really look at the appointment of independent administrators. Simply because you will tend to find most estates have that family tie, which makes it very uncomfortable for someone to act. So historically, Section 50 applications were actually a bit more difficult because the court will take a view that, well, they historically had taken a view that ultimately you need to find misconduct. There needs to be something the executor's done wrong before they're removed. More recently, they're taking a bit more of a view of what's best to get this administration done. Is that more holistic view is actually quite helpful, especially in that case of conflicts between interests or conflicts between the executors. So, for example, we have this this case here of Harris. Ultimately, this is the part where they're saying about it's unnecessary to necessarily find wrongdoing. So it's quite an archaic way that the court, you're looking at it beforehand, where it was if they've done wrong, they'll be removed. If they haven't, then so be it, they'll continue. But these ones are becoming more and more frequent where simply an executor's fallen out with the beneficiaries, usually over people thinking they're entitled to more than they actually are. Maybe there's been a lack of information provided by the executor, a whole host of different reasons, but ultimately they're looking at that holistic view. I would draw your attention to this caution at the bottom of the slide here, though. The wishes of the beneficiaries may be relevant, but they have no right to demand a replacement. So even if there is a deterioration in the relationship, take very great care when it's your client that's maybe caused that deterioration in the relationship if they're making the application to remove an executor. So if you're acting for the beneficiary and they have done something that says, well, they've been the one that causes the issues, and then try to rely on that to say that the executor should be removed, the court will take a bit of a dim view on it. So it is designed for situations where there's more of a general breakdown in the relationship. So this one I found, it just goes to show the extent that some people do. This is Hudman and Morris. So in this one, you'll see that there's expenses for a trip to Australia, around £3,000. Ultimately, there was a dispute about whether an LPA, in the Court of Protection, to decide whether or not those should be paid, cost £100,000. Then the person died, and when it went to the estate, the person actually who was objecting to the £3,000 being paid originally said, well, actually, I'm going to object again in a probate capacity because I'm executor. And ultimately, the court said this is absolutely ridiculous because ultimately he'd wasted £100,000 in the Court of Protection, and then the costs of the probate claim as well, the removal of the executor claim, I should say, all over £3,000. The court decided that there was absolutely no way that he was appropriate to deal with the administration of the estate, simply for that reason of just wasting all the estate's funds. So that comes on to when you should appoint an independent administrator. So 2 times when there's no other willing administrator or no suitable administrator. So no willing is easy. If no one's willing to do it, then you need someone to do it. It's quite straightforward, and the court are quite receptive to that because it's very pragmatic. Suitability is where the court will look at it a bit more, because ultimately, if you have family members who are able to some extent to be able to stay neutral in respect of any dispute, and there's a small estate, then the court might still look at doing one of the family members to be the replacement administrator. It's just making sure that there's sufficient liquidity and complexity to warrant the independent administrator, or simply that the dispute is so intense that actually, even with a small estate, it means that nothing's ever going to get done if you don't have that independent administrator to deal with things. So where it is becoming, as I say, that more holistic view, independent administrators also becoming more frequent, simply because we're seeing the frequency of Section 50 applications increasing as well. As I say, the independent administrators are favoured in situations with a high level of complexity, ongoing disputes, especially the really intense ones where people aren't necessarily looking at the facts, they're looking more at the emotional responses that are just holding everything up. Where there's a high risk claim, or one that's disproportionate, so I'll come back to that one in a second, and then where the beneficiary do not agree that that claim should be pursued. So ultimately, come into that high risk or disproportionate claim element. So a lot of times beneficiaries will say, I'm entitled to X, Y, and Z. Then they realize that actually they don't have the funds to pursue it themselves. They look to the estate to do it. Ultimately, the independent administrator will be able to say that's not appropriate for me to pursue, and can also remind them, pursuant to that Lines and Wilcox case, that ultimately claims for beneficiaries against other beneficiaries should be pursued by the beneficiaries themselves. It's not always appropriate for the estate to sue beneficiaries of that estate on behalf of another set of beneficiaries. Just in case anyone's not familiar with it, Lines and Wilcox was an application for a better order for permission to sue some of the beneficiaries on behalf of the others, and the court refused it, and they said, well, ultimately, this is for the beneficiaries to bring. So options available if there is that situation where you have an independent administrator and they are actually saying, I can't bring that, it's for the beneficiaries, because sometimes the cause of action does actually lie with the estate. So you have these derivative actions and assignments of causes of action. Derivative actions are relatively straightforward but time consuming, where the beneficiaries can bring the claim and say it's a derivative action and ask for permission to proceed in the claim itself. If the court agree that it's actually appropriate for the derivative action to be brought, then ultimately they can just go ahead and let the beneficiaries bring the claim themselves. The second one is then assignments of a cause of action. If the estate has the cause of action, but some of the beneficiaries want to to deal with it, then ultimately they can sell that cause of action to the beneficiaries that want to pursue it by legal or equitable assignment. Legal assignment has a ton of requirements surrounding it, but equitable involvement is still appropriate. You can still proceed with it. It just means you might have to come back and actually deal with some things. To just briefly cover off, derivative actions aren't always favoured, simply because there's where the court have to give permission, you have to issue the claim with the permission as part of it. So ultimately, you could issue the claim, the court could say, well, no, we don't agree, at which point all of that to that point has been wasted. So it might be that you look at the legal or equitable assignment instead, but ultimately the point is that the professional executor in that situation can say, it's a matter for you as the beneficiaries, I can facilitate you to do this, I'm not getting involved. And that's really useful basically for many estates. So costs, because I know that that's something that incoming executors or administrators will be very concerned about. Generally speaking, executors, including independent administrators or replacement executors, etc., all entitled to an indemnity for their costs from the estate. If there's professional executors, it's subject to the usual assessment of any bills. Obviously, it's not done very often, but it is a possibility. If there's a dispute, then ultimately this is where the situation can change somewhat, because the executor has a great tool in their arsenal, which is they can say, I'm going to stay neutral in respect to this claim. I'm going to leave you guys to have the dispute, and I will just affect any settlement or order of the court that's obtained between everyone. So that gives them a good level of cost protection because they've not contributed to the issues at hand. If it's not possible to remain neutral, then it's certainly something that a better order needs to be considered, and that's basically to extend the indemnity for costs to the dispute, and it actually gives permission for them to be involved in the proceedings in a non-neutral extent. The other thing I've mentioned here is the Bedo Light Order. It's I don't know where that's come from, but basically, if all the beneficiaries agree that there should be an indemnity and that they want everything to proceed, then they can provide that indemnity personally, and it has the same effect, just without having to go to court to get an order to do so. The additional point here, subsection 3 of section 50, if there is a lay executor appointed in a will, and then you have an incoming professional administrator to deal with the estate, technically speaking, that incoming person has no ability to charge their professional fees from the estate because the will doesn't allow provision for it, unless you put section 50 subsection 3 in there that says that actually the independent administrator, the professional, can charge their charges from the estate. So that's one of the ones that can trip people up quite often. Just keep an eye out for it. Make sure there's that remuneration clause in the will already. If there's not, you must include that section 50 subsection 3, otherwise it just causes a headache later on. Ongoing trusts as well, that's another one where typically people get tripped up. So with someone appointed, I'm sure you've all seen the wording in the will, executor and trustee, usually what will happen is people will do section 50, removal of executor, and then they'll forget that and trustee part. So dependent on the wording of the will, you could have executor and trustee as one title and say that the trustees are the executors from time to time. It's likely they're going to be caught up in the section 50 application because the trustees are the executors. Some of the problems can arise when you have specific trusts that are built into a will, which perhaps name a different set of trustees or particularly name them, explicitly name them. At which point you could remove them under section 50, and there's an argument that they're still the trustee of that trust. And it can cause all types of difficulty because then you have to pursue a second claim to deal with the removal of a trustee. So there's case law for and against this. That De Silva case there, it does say that usually the court won't have to deal with a section 50 application, and the application to remove a trustee is section 41 of the Trustee Act 1925. You don't have to do both because it will all be caught up together. Other case law actually says the opposite, and you can see that quote from Williams on wills there that says that actually you can have two separate and distinct executor seat and trustee seat within a will. My personal preference is to simply plead section 41 with section 50 or section 116 because it avoids the argument. There's no point in having a situation where you remove the executor, then you encounter an argument of I'm a trustee as well and have to pursue another claim. Just do them all together. It can all be done on the one claim form, on the one set of pleadings, and then ultimately it resolves any other headaches that you might have later on. So coming now to the summary, it's if you can renounce, do it. Amazing. It saves you all the problems you might have. Section 50 applications are usually the one to go to. They're the more expensive, but they're the more specific ones. You can then do the section 116. It's always a consideration to have in there simply because it is cheaper and it has, in fairness, an equally broad reasoning for the removal of the executors. And again, citations in there, just bear in mind that massive caution that comes with it. If you can use a citation, brilliant. You will save yourself a lot of time and trouble. Just don't use it in the wrong situation, which it will just end up being more of a nightmare to deal with than you had thought of before. And as I say, just bear in mind as well that section 41, remove the trustee at the same time, simply because it saves you that headache if needs be later on. And that covers everything. Then I think it's going back then to any questions that people have. I don't know if that's where Sarah will jump back in now.
Yeah, I've got two questions that have been pre-submitted, and I can't see any that's in the Q&A box, but if there are any, please submit them and I can go through them. But I think largely the first question you have dealt with, which is what is the advice to a professional executor in a contested removal scenario?
Okay, so two ways to interpret the question, so I'll deal with both. So the first one is if the professional executor is the one that is threatened with removal. So if there is no good reason for you to stay on board as the executor, then I would usually say, well, actually, just agree to the removal, do it by consent. Because ultimately, where you have a situation where the court could make a finding that you should be removed, although it doesn't necessarily mean that you have done anything wrong, and it can't necessarily be portrayed that way, really do you want to take the risk of having that from a professional reputation perspective, of having that situation where you do have that order going against you? Um, Other way to interpret the question is that if the professional executor is coming into the scenario following the contested removal, um, the main point there is again going to remain neutral if you can. Ultimately, that is the best thing to do from a cost protection perspective. Leave it to the beneficiaries to deal with the dispute if you can. If the cause of action is for the estate, then look at that derivative action, assigning the cause of action, or anything like that to simply say, this is not appropriate for us to deal with as an estate. It could be that someone wants to pursue a claim for £10,000 where costs are going to be £50,000, for example. As a professional executor, you're going to be expected to be given that warning. This is disproportionate. So again, leave it to the beneficiaries. And if you can't stay neutral for whatever reason, then as I say, don't forget your better order just to get you that extra protection.
And we've had two questions submitted from people attending as well listening. So the first one is with the removal of professional executors, would it be better to start with a Section 116 application or go straight to a Section 50?
Would depend on the circumstance, but my instinct leans towards section 50, simply because if you're trying to argue that it's a special circumstance or is necessary under section 116, usually you'll find that a professional obviously is going to be the most appropriate person to deal with an estate. So if you're looking at the section 116 criteria, the court might say, well, I can't see why this is necessary or expedient because you already have a professional dealing with the case. So at that point, I'd be looking more at your section 50, simply because it looks, like I say, that more holistic view that you can say, well, this is done for this reason. And because you're proposing the replacement in there, it just means that everyone has a bit more of a say.
And then the final question that we've got to wrap up is if you know that everybody will approve, is the only difference to a contested application that you will have a more in detail witness statement, or is there an even simpler way?
So I would recommend that you do the detailed witness statement either on the Section 116 or the Section 50 anyway, only because I've had scenarios before where people have said, yes, yes, I will consent when the application is made, then the application's made, all of a sudden they don't return the forms, they either change their mind, and then ultimately you're left with pleadings that are lacking the detail that you want. Um, and you have to then add more work to your own workload to correct that. The other point as well is that if you do have it all before the court anyway, because it's the court's jurisdiction that deals with the removal, even if everyone consents, the court can still sometimes say no. Granted, that is once in a blue moon. So it's better if they can see detailed reasons why that would be the case for the removal.
Fab. Well, thank you very much, John. I can't see that there's any more questions, but that was a thoroughly enjoyable talk, and I think everybody listening will agree that it was incredibly like thorough, and I certainly learnt a few new things in the process. So, as I say, this has been recorded today to everybody. There will be slides and there will be a recording coming out shortly. But thank you to everyone attending, and we hope to see you in 2025.